to our Facebook Live for tonight. I guess we are on Facebook and other places, YouTube, Instagram, just a bunch of different places. But welcome. We're glad to have you here for tonight's session. Just by way of introduction, my name is Tad Davis. I am a family law attorney out here in the East Valley in the Gilbert area, and we help represent families. And our goal is to help you get through your case without screwing up your kids. We focus on just a lot of things to help you do that. One of the things that we have been doing is creating these videos. So on Thursday nights, usually Thursday nights, we basically take a few minutes to answer questions or to talk about topics that we know will be important to different people. So we have been doing kind of a series on trial tips, and tonight is another part of that series. So tonight we're going to be talking about cross-examination and how that can kind of help you build up your case so that you can be better. And just by way of reminder, we also have other guest speakers and people come on here week to week. So we will try to keep you informed on when those are. You can look at the events on our Facebook page. You can also look just other places. So if you do have a question, please feel free to pop in to the chat. We're using a restreaming platform, so hopefully we can make sure that hopefully the chat comes through to me. But yeah, if there's an issue, we have kind of some backup plans there too. So, but yeah, if you do have questions, please chime in there. By way of information, the information that we share here is intended to be educational. It's intended to help you with your case, try to figure out kind of where you're at. It's not legal advice. And the reason it's not legal advice is just because in order to actually be really legal advice, you need to know a little bit more about what's going on in your case. Every case looks a little bit different. And so that's one of those things that is helpful to know. I mean, kind of like what the specifics of your case are before we can actually tell you choose A or choose B, right? So the information here is just intended to be kind of a general information. Hopefully it steers you in the right direction. We as a law firm do offer people the chance to come in and have a consult with us where we can talk a little bit more about the specifics of your case. So if you're interested in that, you can reach out to us by phone or by email, and we'll talk a little bit more about the contact information at the end of this. You can also find that on our Facebook page and other places. So, but thanks for being here. We're going to go ahead and get started, and we're talking today about cross-examination. I'm just going to pull up my outline real fast. Yeah, so cross-examination. So just by way of reminder, if you're going to go to trial, the trial will start and the judge will say, okay, we're ready for trial. So we have, and thank you guys for hitting those comments. That's super awesome. Okay, I can't see them here. So hopefully if they come through, we'll catch them all. So so when the trial gets started, the judge is going to say, all right, we're going to start with trial. If this is the first case that you've done, then what they're going to start off with is the petitioner. So the petitioner, the person who files, gets to start off first, and they get to say, hey, judge, this is what I want you to do, and they can call witnesses. Now, each witness that testifies, whether that's the party themselves or it's a witness that they call, they're going to do a direct examination first. And we covered a little bit about how to get in your direct examination last week as part of our trial tip series. So if you have any questions, just go back to the September, I think it was September 9th, our September 9th video. After they finish their direct examination, so, let's say the opposing party filed, they get to go first. And then after they finish their direct examination, then if you are the respondent, you're going to have a chance to cross-examine them. So if they have three different witnesses, they'll do the direct of witness one, and then you can cross witness one. They'll do the direct of witness two, you can cross witness two. They'll do the direct of witness three, and then you can cross witness three. So cross-examination is going to happen at the end of every witness's testimony. Now, cross-examination is a discretionary thing, right? So you don't have to cross-examine someone. If someone comes up there and they testify like, hey, you know what, I think the petitioner is an amazing person, and I know they really love ice cream, and I really love ice cream too. So I just wanted to come in here and say, ice cream lovers, we deserve, we deserve good news, right? Okay, that's not really a threatening piece of testimony. And sometimes people call witnesses that, like, when they actually get up there and they testify, honestly, like, the court can't use that. Like, what are they supposed to do with that? So if you get a witness that just comes up there and doesn't say anything helpful for the opposing party's case, it's okay to just say, you know what, I don't have any questions for this witness. Now, if you want to make sure, if you want to follow up and just say, okay, look, like, I really want to confirm that, like, okay, like, so that's all you want to say. I mean, I guess you can do that, but to be honest, like, cross-examination is intended to be kind of like punchy, right? Cross-examination is intended to help you say, hey, you just presented your best case, but now I'm going to show you why your best case isn't really that great. Okay. And that's kind of the purpose of cross-examination. So the first thing I tell you is, don't be afraid to just say, you know what, I don't have any questions. But at the same time, if someone gets up there and they say, oh, here's my information, and the information that they share is really, really harmful to your case, or it really kind of cuts at your credibility or anything else like that, you're going to need to cross-examine that witness. So here's a few tips for what you can do for cross-examination. The first thing is to understand what cross-examination is and what cross-examination isn't. So direct examination, the whole idea of a direct examination is that the lawyer or the person doing the examination is throwing out questions so that the witness kind of gives you the answer, right? So, like, an example of a direct examination question might be, hey, do you remember the events that happened on September 16th, 2021? Right? And maybe that's the day that the police were called, or the day that your child got suspended from school, or that they won an award, and so it was a really good day. So the idea of a direct examination is to pull and tease information out of the witness, but you're not trying to tell them what happened, right? Like, in fact, you can get in trouble for leading the witness and saying, hey, do you remember on September 16th when all this good stuff happened for me? And people say, oh yeah, I remember that. You're supposed to kind of like throw a question out and then they have to respond. Cross-examination is different. Cross-examination, you can lead the witness, and all leading is just you're going to suggest an answer in the question, right? So, do you remember the events of September 16th when, like, little Billy got suspended from school? Okay, well, that tells you what the answer is. Like, okay, on September 16th, Billy got suspended. So do you remember that? Yes or no? And the truth of it is that because cross-examination allows for leading witnesses and allows for those types of questions, it's kind of a goal that you should have, that basically you're the one doing the testimony, right? You're the one who's kind of like laying it out for people. You're the one who's telling the story. And when people get hit with those kind of zinger questions, like, I'm going to poke you with these questions, then they're going to start to, I want to say something else. That's not being fair. And you know what? That's the point of cross-examination, right? You want to use cross-examination to kind of poke holes in someone's story. So you can do that basically by framing up your cross-examination and knowing what it is you're going to cover. So the first strategy that we just talked about was ask leading questions, right? You don't have to ask exclusively leading questions, but generally leading questions help you to help kind of tell your story, right? And one of the reasons that it does is because instead of wasting time on, you say, okay, do you remember September 16th? And they're like, oh yeah. Okay, well, what happened on September 16th? And they might say, oh, I remember September 16th because on that day, I went out to the field and I was catching butterflies. And I saw this purple butterfly, and they can just ramble on and on and on. Because the one thing that we have covered also in other weeks is that family court is usually on a tight time frame. So if they want to, and if they're an effective witness, they can use up your time by just sort of rambling in answer to your question, right? And that's kind of like a strategic throwing you off your game, doing all that stuff. So one of the things that you can do is when you ask leading questions, is generally to a leading question, the answer is going to be either yes or no. That doesn't mean that all yes, no questions are leading questions. They're not. It's just if you want to use leading questions effectively, you want to frame it out with questions that kind of answer in yes or no, right? So that's the first tip. If you use yes or no when you say, hey, do you remember this day that this happened? The answer is yes or no. And if someone says, well, I mean, yeah, I remember that day, but you need to understand about what you can just you say, ma'am or sir or whatever it is, right? Like professor, doctor, whoever the person is that's testifying, you can say, that's not my question. My question was a yes or no question. And you can kind of like pin them down on saying either yes and use up your time and try to kind of like manipulate your testimony. You can come back to them and say, stop, don't do that. If you want to do that, you can do that on your time, but on my time, it's either yes or no. The second thing that you should do is and this is kind of counterintuitive, and I'll be honest, lawyers struggle with this, right? When I worked at the county attorney's office, and we would do trials, and you'd watch people kind of cross-examine. It was not uncommon to watch lawyers struggle to do cross-examination. Not saying everybody did, but certainly there were people who struggled with cross-examination, right? And one of the reasons why is because they'd say, well, I don't know what someone's going to say, right? So I don't know what the opposing party's going to say. So how would I know whether or not, like what to talk about on cross? I'm going to wait until they tell me everything that they want to tell me, and then I'm going to ask them questions on that, right? I don't think that's a great idea. And I've had lots of bosses and other lawyers tell me that they don't think it's a great idea. It is tempting to say, well, I'm just going to wait until we get into trial, until we get in the thick of things, and then I'll see what they say, and then we'll go from there. But the reason that I don't think that that is a great idea is because if you're waiting for people to kind of share whatever, the thing that's going to happen is that if they are a great witness, they're going to hit all of the topic areas that they should hit, right? So in a normal family law case, let's say that it's a divorce case, and that you're married, you have property, and you have kids, and you haven't reached any agreements. When you're going to go through your direct examination, you're actually going to want to hit, okay, this is what we want to do about the house, and this is what we want to do about the cars, and this is what we want to do about the toys, and this is what we want to do about the retirement accounts, and this is what we want to do about this is what we want to do about the kids, and this is the parenting plan I have, and these are the holidays that I want to have, and like this and this and this and this and this. It's a laundry list, right? You only have limited time. So someone who is, especially if they're representing themselves, they may not be the greatest witness. So if you wait till the time of trial and you just say, okay, well, I'm just going to cover whatever they covered, what's going to happen is when you get to cross-examination, you're only going to cross them or ask them questions about the topic areas that they covered. So let's say that someone shows up at trial and they say, hey, I really want spousal maintenance, right? So in their petition, they say, I really want spousal maintenance. And then when they get to trial, they don't present any evidence about spousal maintenance. I mean, they talk about their income for child support. They explain, what's going on, but they don't actually say any testimony about spousal maintenance. And because you were waiting for trial, you never cross-examine them about spousal maintenance. Because it's in the pleadings and because you've probably talked about other things, the judge can kind of like parse through and cobble that together and can say, well, this was in the pleadings and I know it was requested and nobody really talked about it at the trial, but I still think everybody was on notice that spousal maintenance was requested. So I'm going to award spousal maintenance in the amount of this much because I believe that that's appropriate under the circumstances, right? So by waiting for trial, you forgot to address spousal maintenance. And by forgetting to address spousal maintenance, you leave yourself vulnerable to the court, saying, well, even though we didn't really talk about this, I'm still going to do it, or I'm not going to do it, right? Maybe you want it and the court doesn't do it. So what I like to do, or what I recommend to people to do, is when you're going into a case and you're looking at like, okay, I know this person's going to testify, build out an outline of what it is, all the different topic areas that are in dispute, right? So in a divorce, it might be real property and cars and retirement accounts and savings accounts and who's going to cover insurance and whether or not we have joint legal decision making, and what the parenting plan is going to be, and who has these kids for Christmas, and what we're going to do about taxes. I mean, all the different things that you can talk about at a trial, right? And then what you want to do is you want to figure out, okay, I know what they wrote in their response. Hopefully, you know what they wrote in their pretrial statement, so that gives you an idea of what they're going to argue at trial. And so what you want to do is you just kind of want to write it out, and you want to prepare so that before you walk into that trial, you have an idea of what it is that you need to cover, right? So when we get to spousal maintenance, I know that I want to say, hey, look, like in this divorce decree, I gave my spouse, we had a property management company and we owned all our own houses. We have like 40 houses between the two of us. I gave my spouse 20 houses as part of the property settlement agreement. I'm making this stuff up, right? Like this isn't real, but I gave my spouse 20 houses as part of this. There is no way that I need to pay them additional income. If they need spouse maintenance, they can sell one of the houses, right? I mean, like that would be easy. They get instant equity. And that's a pretty good argument, right? So if they don't even address spousal maintenance, you can come back and on cross-examination, you can say, hey, as part of the property settlement agreement in this case, didn't I give you 20 houses? Well, yeah. And isn't it possible for you to sell one of those houses and be able to generate some income so that you can get on your feet or go to college or, do whatever, find a job? Well, yeah, of course it is. So basically what you're telling me is that if you just follow through on this plan, like you don't need spousal maintenance, right? Yeah. So that's the second tip that I have is that you should come in prepared. You should know what they're going to say, and that you should break that out by topic area so that you know kind of where you're going and why. The other thing is that helps you to identify, if you know, okay, when this topic comes up, I know that their strong point on this topic is this, right? You can pick a topic and you can identify when my ex talks about this, it usually is pretty strong, right? Maybe they are super charming. Maybe they are just very believable. Maybe other people just flock to them. They're very charismatic. And so if you see that, then you would know that, oh, okay, well, hey, look, this person's super charismatic. So because they're super charismatic, I want to, I know that they're going to do this really well. But you can also identify things that they might not do well at all, right? Some of the weak links in their argument. Like maybe their argument is like, well, I deserve to have all of the parenting time, or I deserve to have all the parenting time because, I'm mad that you didn't let me, go to doctor's appointments 2 years ago or something like that, right? Well, okay. So one of the things, if you know that that's going to be their best argument, they think they're going to make like a parental alienation argument or something like that. One thing that you could do is you could kind of figure out, okay, well, look, like if you're making that argument, what is my best counter argument? And then just even if they don't make the argument, even if they don't say anything about it in the direct testimony on cross-examination, you can hit them with the weak point of their argument, right? So a lot of that is just kind of sitting down, figuring out what it is that they're going to say, what it is that you're going to say, what you think their strongest argument is, and what you think their weakest argument is. Hit them with the weakness, like show how it doesn't quite fit, and then hit on their strong point and go from there. Okay. And we're on tip number 3. All right. So tip number 3 is don't go for the kill shot, right? Don't go for the kill shot, right? What I mean by that is that in cross-examination, when you're asking yes or no questions, you can usually paint people into a corner, right? So the way you do that is that you say, okay, isn't it true that you over these last few months that you have been living, with your significant other, right? Well, yeah, of course. Yeah, I've totally been doing that. And isn't it true that because, like while this divorce has been going on, you've been living with your significant other, and so that you've been busy, like you guys have gone on dates, you guys have done other things. Well, yeah, we've totally done that, right? And so because of that, like you haven't been as available as you once were, like say 2 years ago when you weren't going on dates with your significant other. And they'll say, yeah, no, I agree with that. Okay, so isn't it true that that basically over the last 6 months that you have had significantly less contact with the kids than you say you have, right? and they'll be like, oh, well, I don't know about that. And then you can, pull out your phone records or whatever it is that your exhibit is. And you can say, well, here, I'm showing you this. And, 6 months ago, you used to call the kids every day. And now over the last 6 months, like, you're lucky to call them maybe once every 2 weeks, right? I mean, isn't that true? And they'll be like, well, I mean, I guess so. I don't know. And this is where they're starting to kind of panic, right? Because you're pinning them down, you're painting them into a corner, right? So the point of doing an examination like that is to try to get to the end result. And the end result is probably going to be, you want to show that they are a bad parent, or that they're not, that they don't care, or that the relationship with the kids is suffering. So the kill shot here, like the man, I finished you off, is you're going to get all the way down, and then you're going to say, no, so isn't it true that you're a horrible parent, right? Or isn't it true that you don't care about our kids? But here's the thing, who says yes to those questions, right? Who says yes? No one. So if you say, hey, isn't it true that you are a horrible parent, right? Everyone's going to say, no, of course not, right? And now it looks like maybe you've overreached, right? But now it looks like, oh man, like, well, okay, yeah, of course they're not a horrible parent. Yeah, they may have been preoccupied with the relationship, but like, yeah, come on, that's an overreach, right? So what you want to do is you want to paint people as close as you can into a corner without actually painting them all the way in, right? Because here's the thing, judges are listening to this stuff, right? Like, judges are paying attention. And so if you see judges, and they're paying attention and they're taking notes and they're doing all these things, like, they will take care to basically ensure that, like, okay, like, I see what you're doing, you got them all the way there, and they understand what you're doing, right? You don't need that final question. So that was tip number 3. Don't ask the final question. No one's going to admit that they're a horrible parent, or at least it's very unlikely that they're going to admit that they're a horrible parent. Nobody's going to admit that they're a liar and that just no one's going to admit that, right? So don't worry about asking that final question, because it's almost never going to pay off. So, hey, Trisha. So, yeah. So, okay. Tip number 4. All right. Don't rehash the case. Again, another tip that the attorneys really struggle with. But the worst thing that you can do on cross-examination is to just go over and repeat all the things that the other person said on direct examination. So I'll give you an example. Let's say on direct examination, and for our purposes, mom's going to be doing the cross examination, and dad is going to be doing the direct exam. Is giving testimony as part of the direct exam. So dad gets on the stand and he says, "Yeah, you know what? We've been in a relationship for 10 years, and over the course of the 10 years, I've noticed that mom has a major substance abuse problem, and that she will pick something. She drinks alcohol every night, all night long. She's always drunk. She's always falling apart. It's just bad news, right?" Okay, so and then dad's testimony keeps going. He says whatever he says, right? If the first thing that you do, if you're mom and you're standing up there and you're going to do cross-examination, the worst thing that you can do is say, okay, so is it really your testimony that I'm drunk all the time? And it's like, well, what's the answer going to be? It's going to be, yeah. Is it really your testimony that, like, I pass out in the lawn? Yeah. Is it really your testimony that, like, I'm vomiting everywhere, and I'm sick all the time, I have no idea where I am, that I wake up in unfamiliar places and you have to come pick me up at 3 a.m. because I have no idea what's going on? If that is your lead in on your cross, that's not a great lead in, right? Because all you're doing is you're giving them a chance to reinforce the message that they already did, right? So don't rehash their testimony. You need to cut into that testimony, right? So instead of asking things like, is it your testimony that I do all these awful things, right? You can talk about it and you can say, you testified about a substance abuse problem, but isn't it true that you also have been drinking, like at all the instances in which you cited that you were also drinking? Well, yeah. And isn't it true that on, September 16th, 2021, that you were at a party with your friend Steve, and you got so drunk that you had to be brought home by Steve? Well, yeah. And isn't it true that in fact, like 2 weeks ago, like you were arrested for a DUI? Well, yeah. What you're doing is like you're not directly confronting them per se about the allegations against you. What you're trying to do is you're trying to say that these allegations against you are coming from a biased source, right? Like, so the tactic that you're using is really just to frame it up to say, hey, look, like, okay, you're saying all these awful things about me. I know that if I ask you directly, like, are these, do you really believe these things are true? You're going to say yes, right? Because they just testified that they were true. They swore an oath and they said, hey, I promise to tell the truth. But, just because they promise to tell the truth doesn't mean they're actually going to tell the truth, right? So what you do is that you basically get to a point where you can say, hey, look, like, I'm going to attack you, but I'm going to say that you're biased, right? Like you have a bias against me, and that bias is what's driving your opinion. And so, you're saying that I was drunk all the time, but you're drunk at all of these, right? How do you even know what I was doing? Well, I mean, I was told by Steve that that's what you're doing. So you didn't even see me do anything. No, I didn't see that, right? That's kind of the power of cross-examination, that if you don't use it just to rehash what they said and you kind of bring up your own information, then that's really going to help you to kind of structure your presentation so that you can kind of get the maximum benefit from your cross-examination. All right. I think we are on tip number 5. I just have a couple more, and then if you do have any questions, like I said at the beginning, if you have any questions, please feel free to share them in the chat. It looks like I'm getting them all here. So tip number 5 was to use links to help you out, right? So, and I'm going to explain kind of what I mean here, but using links can be really helpful because what you're trying to do is you're trying to string together information. Now, there's 2 purposes to stringing together information. The first purpose is that maybe there's a piece of information over here that that if you just kind of follow these links, that it's going to lead you to a place where it's going to connect to another piece of information that you need over here, right? So if I have this piece of information, when I ask this question down here, I'm going to have a head start on that question, because I mean, essentially you're setting up your questions, right? So if they admit that, yeah, like this is true, then they're going to have to admit that this is true, even if this is something that they don't want to admit that is true. So essentially what you want to do is, if there's specific facts that that are generic facts, that are basic facts, that are not things that are controversial, and that they're going to admit to those facts, you can just ask those right here at the beginning, right? So what, like, isn't it true that your car is a Mazda Miata, right? A 2-seater Mazda Miata. Yep, that's true. Okay. Right. And what you're thinking is that, you have 10 kids. And so a Mazda Miata that seats 2 people is never going to be a great car to drive around 10 kids, right? So by getting them to admit that their car is a Mazda Miata, and maybe you say, okay, you have a Mazda Miata. Yes. And isn't it true that you love your Mazda Miata? Yep, I totally do. And you're making payments on the Mazda Miata. Yep, I totally am making payments. And you never want to sell that car. Nope, never want to sell it. And right now you don't, like the Mazda Miata is your car. You're not planning to buy any other cars. Nope, not planning to buy any other cars. Okay, so, wouldn't you agree then that the Mazda Miata is incapable of driving all of our 10 children around the town? Well, yeah, I mean, the Mazda Miata is not going to fit. And you're not going to buy another car. Nope, not going to buy another car. Okay, so you are incapable of getting our kids around town, right? So therefore, whatever your end goal is, right? Like, you can't have parenting time whenever we're driving or something. I mean, like, the end result is going to be contingent on what it is that you're trying to prove. But the long and short of it is that by getting them to admit that their car is a Mazda Miata, that they're not going to buy another car, that they're financially strapped to the Mazda Miata, then your end goal is accomplished because it proves that they can't drive around all 10 kids, right? So generally speaking, ways to link up facts would be start with super general stuff, right? Start with the general stuff that you know that they will admit to, and then try to use that as a chain to get to more specific stuff. That does tend to help. The other thing is that, you know, if you have like the Mazda Miata thing, that's not really a general question per se. I mean, maybe a little bit, but you know, if you start with a Mazda Miata question like that, nobody sees it coming. That really what you're talking about when you're talking about the Mazda Miata is about failure to be able to transport the kids, right? Unless you've made a big deal out of it that, you know, they love their Mazda Miata and you've written that in all the pleadings and you've talked about it or you've argued about it in the past. And, you know, I mean, like, then they might see that coming. But generally speaking, if you can find facts that are really going to help you and are able to kind of link those together as you move across, you're going to be in a really good spot because you're going to be able to say, hey, like this is, you know, like this is this key factor. And by, you know, moving that across over here, you know, like people just don't see it coming, right? But, you know, general to specific isn't end all be all. I mean, there's lots of ways to do it. The other thing to remember is that sometimes there are facts that you need to get in, but they don't categorize well, right? Like, so that, you know, like, this is a fact from your history, and this is a fact from a police report, and this is a fact from something that happened at school, and this is a fact from, you know, a previous incident, and this is, you know, so you kind of have facts all over the place. You want to try, because remember, judges are listening to this, right? Judges are listening to this. They want to understand this. They want to they want to make sure that they're getting everything that you're telling them. But the reality is that, like, you know, if you don't explain it in a way that they understand, if you're like, you know, kind of like, I'm going to shoot here and then shoot here and then shoot here and then shoot here and then here. If you're all over the place in your cross-examination, you might be able to effectively kind of like mess with the testimony of the person you're collecting the testimony from. But the downside is that you also might make it to where it's hard for the judge to follow where it is that you're going, right? So always favor organization over like the haphazard, haha, I got you, right? Like, organization's going to work better. If you're going to get them, you're going to get them just by asking consistent questions and kind of trying to link things up that way. Okay, last tip, and I was gonna bust out a piece of paper. Let's see, because I was just gonna show you something. Here, I'm just gonna grab some paper from down here. So, okay, it's just on my notepad, but I'm just gonna pull it out and show you guys. Okay. So this is just a normal piece of paper. I grabbed it off a legal pad. You can write in a 3-ring binder. You can write on a white sheet of paper. You can write on a colored sheet of paper, grid paper. Any paper is gonna be the same. But when you're thinking about like how to structure your case, right? How to make it easier for you to follow this and make sure that you're able to do a good job. What I'm going to tell you is that you want to kind of build, I'm just going to draw something real fast here. I know this is super simple, and I apologize for my line being bad. I have like 3 inches of counter space on here, desk space, because my keyboard's right here. But so anyway, you're going to want to draw a line, okay? And this is why you're going to want to draw a line. You're going to, and I know it's probably backwards, but that's okay. Cross. Okay. Sorry if my handwriting's horrible, but okay. So here's our thing, right? So right here in this column, this is what you're going to write on their testimony, right? So if you're coming pre-prepared, what you could do is you could just say, okay, spousal maintenance, I expect them to say this. And then we're going to get into kind of like your cross-examination questions. You could even like have that typed in. If you wanted to get really fancy and type all this stuff out, you totally could. If you don't want to get that fancy, you could even just have a separate sheet of paper where you identify, okay, like these are my arguments that I'm going to make. The opposing party, so when the opposing party testifies, you're going to put their information right here. What is it they said, And if they say something particularly damaging, what I like to do is I like to say, so I'm going to say damaging, right? And then what I'm going to do is I'm going to put a star by it, right? So they said something damaging, and then I'm going to put a star by it so that when it's my turn to do my cross-examination, I know I need to hit that, right? So whenever they say something damaging, right here, or if you already know that there are their best arguments here and the weakest arguments here, you can pre-plan your cross-examination by kind of writing your questions right here. But if you hear something that's damaging, you can say over here. So they say something damaging, and you're going to draw an arrow, and you're going to say, okay, yeah, and here's my question that I'm going to be able to respond to that's going to help me there. But let's say that you don't think of a question super fast. That's fine. You can even just do like a different arrow system, right? Like where you're like, okay, so you're still on the same page. So you have this damaging information, and the arrow comes down here, and then you have another star by it to say, hey, like you need to hit that. You need to hit that when you go through it, right? The whole point is that you're trying to make there's a lot of information. I mean, this is information overload, right? Like when you're doing direct examination, it's a little bit more structured because you know what you're trying to get out, right? Like I'm trying to do this, so I'm gonna go through these pieces of information, and I'm just gonna put it out there. On cross-examination, you're trying to do two things, right? You're trying to respond to the information, the prompts and information that you're given, and you're also trying to get your story across, and you're also trying to use this to kind of testify, so it's like they say this is all ABC, and you're like, no, it's XYZ, and so you're having to kind of attack them on that, but then you're also trying to say, and this is why XYZ is actually right? So it's a fire hose of information. It's coming fast and furious. This is just one simple way of doing your notes. If you want to be a little bit more dramatic about it to where like it's clear, you can even go as far as to just fold this piece of paper, right? And then you can write on one side, okay, like this is their information, and these are my questions, right? I usually just like the line, because if they say something and I think of, like, okay, well, this is the question that I'm going to ask to refute that, having to flip over the paper, it takes a half a second, but that's a half a second I don't want to spend. I don't want to lose a half a second, because in addition to writing out my thoughts, you also have to be like thinking and listening so that you can hear what it is that they're saying, right? Because if you're so excited about writing down your thought and you miss something super critical, there's no take backs on that, right? Like, I mean, you can't really say, hey, like, what did you say? And they'll, I don't remember. Meanwhile, the judge like totally remembers and wrote it down. So, yeah, hopefully that's helpful in terms of doing cross-examination. I really enjoy these trial series. I think it's really good for people to be better prepared for trial. I think these are super helpful just in terms of knowing what's coming, regardless of whether you're working with an attorney or you're just doing it yourself, just to kind of understand like the process and kind of how it goes. I said at the beginning, but yeah, we have a law firm, and it's here in the Gilbert area. We're happy to talk to you about your individual case where we can go through all this stuff. So things like direct examination and cross-examination, when you're working with us, we take care of the direct examination and cross-examination, right? Certainly you can help us by like providing us information and giving us, okay, like these are the things that I really want to hit, and this is super important to me, and we can kind of help you frame up like how all that fits in. But you don't have to worry about doing the witness outlines and everything else like that. Like that's what we do. So if you're interested in following up with us and scheduling a time to go over your case, you can always give us a call at 480-435-9999. You can also email us info@taddavislaw.com. That's TADDAVISLAW.com. You can also go to our website, taddavislaw.com. There is a chat bot on there that you can kind of hop on and get some information. And you can message us on social. Like there's lots of ways to get a hold of us. But yeah, we're happy to help walk you through and just kind of give you our 2 cents on what your case might look like and how all that works. Yeah, and if you do have any questions, please feel free to reach out. We'd be happy to talk to you then. we will be back next week. I'm not going to announce the exact topic because we're still working that out, but we will be back next week again to talk about just different things that are going on. And yeah, if you have any suggestions on topics you would like us to cover, please feel free to send those in. Shoot us an email. You can even text us, give us a call at that number, the 480-435-9999. And we'd be happy to talk to you about that then. So we'll look forward to speaking to you next week, and have